Welcome to the revision lecture series by M.P. Siddhesh. This is part 3 of the revision lecture on legislative relations or center-state relations. Please watch all the parts in this revision series for a complete understanding of the topic. In this part, we shall cover the following topics: the doctrine of severability, the doctrine of eclipse, and we shall be discussing parliamentary legislation in the state field and the role of occupied field in the next part of this revision series. The only reason is that I am trying to keep the videos below 15 minutes. We will try to stick to the following lecture structure throughout this lecture. First, we shall understand the core concepts behind all those doctrines. Next, we shall take a look at how those doctrines operate and what their effects are. Next, we shall briefly deal with the relevant case law, and finally, we shall be undertaking some comparative analysis wherever possible for a better understanding of all the topics involved. Let us start this lecture with the doctrine of severability. In ordinary language, to sever means to cut off from. However, in the legislative context, an unconstitutional provision is severed or cut off from the rest of the statute which remains valid. The doctrine of severability can become applicable in two scenarios. That is, number one, in the case of violation of fundamental rights contained in Part 3 of the Constitution, and number two, in case of overstepping or exceeding of legislative competence by the concerned legislature. In both cases, the unconstitutional provisions are severed or cut off from or are removed from the valid provisions. Since this is a lecture on legislative relations or the center-state relations, we shall only deal with the doctrine in the context of legislative competence. We shall deal with the doctrine of severability and the doctrine of eclipse in the revision lecture covering the topic of fundamental rights. For now, let us take a look at some of the important elements concerning the doctrine of severability. Some important elements concerning the doctrine of severability are: number one, intention of the legislature is relevant and can be looked into. Compare this with the doctrine of colorable legislation, which was discussed in the previous part, wherein the intention of the legislature is beyond the scrutiny of the courts. While looking at the intention of the legislature, the title clause of the impugned act, the stated objectives of the impugned act and its provisions may be looked into by the courts. Next, if it is found that the remaining portion of an act can survive after the unconstitutional provisions have been removed or severed, the act survives. On the contrary, if it is found that the act cannot operate without the impugned provisions, the whole act fails and nothing survives. Let us understand some more important points concerning the doctrine of severability. In the context of legislative relations, the doctrine of severability comes into play or comes into effect after the doctrine of repugnancy. That is, only the repugnant portions are severed or removed or expunged from the impugned act. Next, it must be noted that if the surviving act cannot operate without alterations or modifications by the court, the whole act must fail. Why is that? One of the basic rules of separation of powers is that judges cannot legislate. Therefore, modifying the impugned act will amount to judicial legislation, which is not permissible in India. And lastly, if the act under challenge was expected to operate as a complete code, or if it was supposed to be a whole legislative scheme and certain portions of the act are declared unconstitutional, the entire impugned act ceases to be operative. Now let us briefly skim through the case of RMDC for a better understanding of this subtopic. Please remember that we have also discussed this case in the context of the doctrine of territorial nexus, which was discussed in the first part of this lecture series on legislative relations. Please feel free to revise the doctrine of territorial nexus if you want. Getting back to the case of RMDC, please note that the state law under challenge was applicable to both gambling competitions and competitions involving skill. So what happened in this case? What was the result? It was held that the state could legislate with respect to gambling and betting, but not other competitions involving skill. It was held that even if the provisions relating to skilled competitions were severed or expunged from the state law under challenge, the state law could survive and remain operative without any difficulty. Hence, in this case, the unconstitutional provisions of the concerned act were severed or expunged from the remaining act, and the rest of the act continued to remain operative and effective. Now let us start with the doctrine of eclipse. Let us try and understand the core concept behind the doctrine of eclipse. In layman's terms, to be eclipsed means to be overshadowed or to be superseded by someone or something. In the legal context or the legislative context, to be eclipsed is to be suspended, to be placed in abeyance, or to be made dormant. Therefore, when an enactment or law is said to be eclipsed, it is not nullified or it is not made void. It is merely suspended or made dormant for the time being, and the impugned legislation may be revived subsequently by curing the defect. Please note that we are discussing this doctrine only for the sake of clarity. Students often get confused between the doctrine of eclipse and the doctrine of severability. Therefore, in the next slide, we will try to distinguish between these two doctrines. So let us try and distinguish between the doctrine of eclipse and the doctrine of severability. First and foremost, the doctrine of eclipse only applies to pre-constitutional laws, and on the other hand, the doctrine of severability applies to post-constitutional laws. In the case of doctrine of eclipse, the relevant article is Article 13, Subclause 1, and in the case of the doctrine of severability, the relevant article is Article 13, Subclause 2. Next, in case of the doctrine of eclipse, when laws are said to be eclipsed, they are not declared void. They are merely suspended and may be revived with a change in the concerned constitutional provision. On the other hand, in case of the doctrine of severability, the laws are declared void and cannot be revived by subsequent amendment or legislation. On the contrary, in the case of the doctrine of severability, the unconstitutional laws are declared void and cannot be revived by any subsequent amendment or legislation. Thank you for watching. I am confident that you have understood all the concepts discussed in this revision lecture. We upload 2 new videos every Tuesday and Saturday, and you can request for a particular revision topic and we shall try to cover the same. If you like the content, please like this video and subscribe to the channel. Thank you once again.